We turn to the next case on this morning's docket, case number 120818 in the matter of Pamela Thompson.
Good morning. May it please the court. Matt Franzenberg appearing on behalf of the Office of the Disciplinary Administrator. Mr. Chief Justice, I would request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This is an original case in attorney discipline against the respondent, Pamela Thompson. There were 2 separate investigations and case numbers combined into one panel hearing that took place on December 4th, 2018. The first case was basically a retirement case, a 401k case, where Ms. Thompson had set up for her law firm a 401k retirement plan for herself and for employees. And 2 of those employees, Ms. Brewster and Ms. Manny, chose to participate in that plan. In February of 2017, Ms. Brewster filed a complaint with our office alleging that Ms. Thompson was failing in her duty to timely remit the payroll deferrals from the employees into a 401k account. Investigation bore that out. Ms. Thompson was the designated plan administrator and the plan trustee. It was her responsibility to make sure that those funds were deposited within 7 days of payroll. And for basically the entirety of 2016, with 1 or 2 exceptions, she failed to do that. Essentially, Ms. Thompson was using her employees' money for free for most of a year. During that investigation, in February or March, Ms. Brewster and Ms. Manny relayed to the investigator that they had concerns that Ms. Thompson was taking money in estate cases without permission of the court, and that she was possibly taking money without doing work. Again, that occurred, those statements occurred in February and March, and also Ms. Manny indicated to the investigator that they had been searching for those 2 estate files throughout the office and they had not found them at all. 2 to 3 months later, May 26th of 2017, Ms. Thompson did self-report that she was in fact taking money from those 2 estates. The first estate, the initials of the decedent were BW. That estate was worth roughly $58,000, and Ms. Thompson wrote herself 5 checks on 5 separate occasions between July of 2016 and February of 2017 to the tune of $57,000. So nearly the entirety of that estate and the funds within it. The second estate was EI, and in February of 2017, Ms. Thompson took 3 checks to herself, tallying over $30,000 out of $72,000 in that estate. Ms. Thompson claimed at least some of those monies were for fees or fees that she had earned in her duty as the executor or administrator of the estates. She never sought, nor did she ever receive permission from the court to take that money. It's important to note that Ms. Thompson was appointed by the court in those 2 estate cases to be the administrator and the executor. She had very little oversight, and so it was very easy for her to take advantage of that position. She was the one that had control of the money coming in and the money going out of those estates, and took nearly $90,000 from those 2 estates. Prior to the hearing in December, our office and Ms. Thompson entered into stipulations. Ms. Thompson stipulated to the underlying facts in the investigations. She also stipulated to violations of the rules of professional conduct, those rules being 1.15, 8.4C, and 8.4D. The panel concluded that she did in fact violate those 3 rules, and the panel went so far as to say that they believed her actions constituted selfish and dishonest conduct. At the hearing, Ms. Thompson testified. She had a couple of other basically character witnesses testify on her behalf, and she had a therapist testify on her behalf. Ms. Thompson and her therapist both talked about the difficulties that Ms. Thompson was facing in her professional and her personal life, including depression and anxiety, but it was never really clear how those issues contributed to taking $87,000 plus from her clients' estates and nearly $4,000 from her employees for the year of 2016. It's important to note that even at the hearing, Ms. Thompson admitted what she did was wrong, and she knew it at the time she did it. I'm sure Mr. Ambrosio is going to note for the court that Ms. Thompson has no history of discipline. That is accurate. However, these are egregious violations in this case. First and foremost, the amount of money that she took that did not belong to her was roughly $90,000, $87,000 plus from her clients' estates, and almost $4,000 all told from her employees that she did not remit into the 401k accounts for them. This was not a one-time bad decision on her part. This was not a situation where Ms. Thompson looked at her bank records, realized she was well in debt, and in a moment of weakness wrote herself one large check and regretted it later. This occurred over 8 separate checks on 7 different dates over the course of roughly 8 months in 2016 and 2017. The clients in this case were especially vulnerable, as these were estates for obviously people who had passed on. Again, Ms. Thompson was in a position with basically no one looking over her shoulders, and she took advantage of that. I would suggest that her employees also put their trust in Ms. Thompson to take the money from their payroll and deposit it appropriately into the 401k accounts, and she violated that trust as well. What was somewhat confounding to me, and also I think the panel, was that Ms. Thompson was able to pay back all of this money to the estates and to fund the 401k accounts in a fairly short amount of time. And her testimony was that she and her husband had assets. They had property they could have borrowed against for loans. She ended up, I believe, getting some loans and also borrowed money from family or friends to pay back this $90,000. But she chose not to do that. She chose to take money that didn't belong to her rather than ask for a loan or other assistance. And I think it's also important to note that there were stipulations that were entered into prior to the hearing. Ms. Thompson testified, and the panel found that her testimony was contrary to at least one of those stipulations, and they found that that was deceptive. That is in their panel hearing report. This case basically comes down to what sanction is appropriate. I would direct the court to consider ABA standards for imposing sanctions. The panel on page 20 of their hearing report discussed several standards. I'm going to touch on 3 of those. Standard 4.11 is disbarment is appropriate when a lawyer knowingly converts client property and causes injury or potential injury. And in this case, luckily, the estates and the heirs did not suffer because Ms. Thompson was able to pay that money back. However, the potential injury was very, very great in this particular case. I would suggest that Ms. Thompson also converted her employees' funds. They were also taken and used for Ms. Thompson's purposes inappropriately. Standard 5.11, disbarment is appropriate when the attorney engages in serious criminal conduct, including fraud, misappropriation, or theft. The panel in their hearing report actually stated that they considered Ms. Thompson's behavior and her actions, and they looked at the criminal elements for theft. And they found that although she wasn't charged with any crimes, that her behavior actually met the statutory elements for theft, not just theft, but felony theft, multiple counts. Standard 7.1, disbarment is appropriate when an attorney violates a duty owed as a professional with the intent to benefit the lawyer and causes serious or potentially serious injury to the client, the public, or the legal system. And I've already covered the injury, potential injury to clients or her employees, but I would suggest that by failing in her duty to maintain her integrity, Ms. Thompson did injure the public, and she also injured the legal system. And the hearing report also finds that she violated 8.4D, I believe, due to the fact that she was taking money without asking the court in those estates, and she damaged the legal system as well. I know that this court has stated on multiple occasions that each of these disciplinary cases rises and falls on its own facts, but I did find at least 5 cases since 2013, disciplinary cases where attorneys were found to have converted funds that did not belong to them, and all of those attorneys were disbarred. So even though this case will rise and fall on its own merits, there's a strong history in this court of disbarring attorneys who convert funds and property that does not belong to them. Based on the request at the hearing panel, I presume Mr. Ambrosio and his client will be asking for suspension rather than disbarment, which is what I'm asking for. The problem that I have is that Ms. Thompson was in a special position of trust with her employees and with these estates. And knowing that no one was watching over her, knowing that she had the means through other alternatives to gather funds if she needed those funds, she chose to take money that did not belong to her and use it for her purposes. I don't know how we remedy dishonesty. If she were to be suspended and then reinstated at some point, how do we know that this won't happen again? And that's my concern, that we cannot put protections in place to remedy dishonest conduct by an attorney. There are multiple reasons why we impose sanctions on attorneys who are found to be in violation of the rules of professional conduct, punishment of that attorney, deterrence for other attorneys, obviously. But my concern here is the public interest and protecting the public from this happening again. I use this argument at the hearing, but almost everything we do as attorneys, someone asks us a question and we give the answer, it depends. In a world of it depends, in this case, one of the first things we learn in law school and as new attorneys is we do not take money from clients. That is one of the most clear rules that's pounded in our heads from the start. So in this particular case, Ms. Thompson took nearly $90,000 that did not belong to her. She used it for her purposes. It is selfish, it is dishonest, and I think the appropriate sanction in this case is disbarment.
Do you have any questions?
Thank you, counsel.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, may it please the court. The facts as described in the panel report, the violations as described in the panel report and by my colleague are dead on and accurate. That's what happened at the hearing. That's what the facts are. Those are the facts from the beginning. The whole question is what disposition, what happens to this lawyer? What is the punishment that sends a message both to the bar, to the public, and to her that we can't allow this type of activity? We are asking today that the court indefinitely suspend my client as opposed to disbar. We think that the indefinite suspension will take care of all of the issues raised by my colleague in the disciplinary administrator's office. The money was paid back, and I understand she doesn't get a pat on the back for that. The money was converted, it was taken, but she did pay it back. And I think we have to address this issue that the dissenting opinion in the panel report addressed and my colleague also addressed. She had the assets, she had the real estate. She could have borrowed money on the real estate. She could have borrowed money from friends and family, and she chose not to do it. And the question that is being posed and was posed at the panel, and we tried to answer to the therapist, is why? It's because she was depressed, she had anxiety problems, and she had PTSD as is described in the panel report. You know, we've got a number of committees now with the bar, the wellness committees, where we're trying to locate people who have these problems early on. If we had found early on the problems that Ms. Thompson had, that she was depressed, that she was anxious, that she was having trouble generally getting work done, etc., then maybe the bar could have gone to her, addressed her through KLAP or through these new committees that we're forming and said, you need medication, you need to work on this anxiety, you need therapy. And although she started the therapeutic process before these cases came to the forefront, it was not enough and it was too late. And we need to start identifying these things. We tried to have, and the therapist explained that my client was in, I think the word she used was a fog, when she took that money, she converted it. And I don't know what happens. I've argued these cases before this court into panels for the last 10 or 12 years, and I don't have an answer. My colleague is right. We're taught from day one in law school, the professors say, you don't touch somebody else's money. That's the death knell to your license. And they go over it and go over it, yet lawyers do it. Some lawyers do it, frankly, because they're less than honest. Some lawyers do it because they're thieves. Some lawyers do it because there's pressure and stress. Some lawyers do the wrong thing because of their mental problems, the anxiety, the depression. I've never had these things. I don't know what happens. I don't know how you deal with the grief that she dealt with. Her father becomes addled in his age, and he has to be put in a home. The mother has a stroke, and all of these things are on her shoulders. And I'm not excusing, and she's not excusing either, and neither is the discipline administrator's office. But these things are important to look at. There's a difference between the lawyer who takes him his trust account for no reason other than maybe his wife called him on a Friday and said, or his spouse called him on a Friday and said, we owe $2,500 on the mortgage, and you need to pay it, and he or she gets tense, and they take that money. But when you labor with the health issues, the stress issues, the mental illness that my client had, and what we described to the panel, not excusing. And she's not going to ask for excuse. She's not going to say, excuse her and give me a chance to practice. After talking and after visiting with her since the panel report, you notice we changed from asking for a 1-year suspension to an indefinite suspension. The woman who appears before you today is so much different than the woman at the hearing and the woman who first came into my office so long ago. It's been a gradual change where she is working on herself, working on herself. And frankly, she'd like to come back after 3 years. She'll need that hearing to come back. She wants to practice law again. She was clean for 33 years as a practicing lawyer. She was involved with the Wichita Bar. She taught CLEs. She helped and worked in the community. She taught in the community. She gave lectures to lawyers and non-lawyers alike. And again, I'm not asking for an attaboy, but I think it's important to look at the person who converted the funds as opposed to the lawyer who he or she acts as a thief and just takes it without some of the things on her shoulders. The judge, wonderful judge, won't mention his name, who testified under subpoena said, my words, not his. This is an aberration. My word. I think what he said was, this is not the behavior you described to me, Ambrosio, is not what I saw on the woman who appeared before me day in and day out in court. Somebody from the district attorney's office, who's also on our wellness committees now, said and testified she's a good person, a good lawyer, she's honest and above board. And I think one of the most telling things that happened, her pastor testified. Now, I'm not religious. Those of you who know me, I'm not religious. I'm not a believer. My client is. And she actually confessed to her pastor. And that began the process to get her back to where she needs to be. So what I'm saying is, you don't have to excuse her. She understands that she sinned, that her transgressions are very serious. Some of the most serious transgressions that any lawyer can commit. But she's changing, she's working her program, she's working with KLAP, she's working with her sponsor, she has friends in the community, she has, her husband is on her side throughout this matter. Everybody is trying to help her reform and change. She's working on what she's going to do with her life from this point on. She's a middle-aged woman. I almost said relatively young. I've got to be careful, so careful. I'm always the oldest person in the room anymore. She's a younger woman, and she's working on the rest of her life. With your permission, she would like to address you.
Certainly.
Come on. Right here. Just relax. We'll do fine.
May it please the court, counsel. I'm Pamela Thompson. I stand humbly before you today, and I'm in a position that I never imagined could occur. Throughout my practice, I've strived to run my practice and handle my cases, thank you, with diligence and integrity. I have worked hard to continue to educate myself, to provide good quality work, and to represent my clients to the best of my ability. I take responsibility for my actions and my lack of action. I accept that I made errors and I showed horrible judgment. My behavior was not in line with my values or my beliefs. It was wrong and it was not acceptable. And I agree with what John has said as far as accepting what I believe would be a correct recommendation, or we ask that I be suspended indefinitely. My behavior was not in line with my values or my beliefs. It was wrong. I've worked hard to understand what happened and to take corrective action, and it will never happen again. Throughout 2016 and 2017, I came to a tremendous crisis point in my life. I struggled with depression and with anxiety, and I did not recognize what was going on. I was working far too many hours at 65 to 70 hours a week, and I worked hard to try to tackle each of the client's projects, take care of administrative matters in the office, but I couldn't keep up. I could no longer keep track of things. During this time, I became the caretaker for both my parents, as both my siblings live out of state. My dad has dementia, my mom was failing, and my mom has had several hospitalizations and suffered a stroke since that time. As the stress increased, I did not eat right. I was always on the run from task to task. I did not sleep well, and I stopped sleeping through the night. As the depression became more severe, I stopped exercising and I started gaining weight. I stopped doing almost everything that I enjoyed doing, like reading, dinners with families and friends, and hobbies like crafts, hiking, photography, walking my dog. Then December 5th of 2016, I went to pick up a friend who was only 59. We were going to have lunch, and I found that she had had a severe stroke. And that shock and the trauma of finding her and not being able to save her was more than I could process at that time. I now had grief on top of the depression, and everything went foggy around me, and I struggled to get through each day. I tried to be strong. I tried to push through, but that shock and the grief was too much for me. I called my pastor, and I talked to him about grief and acceptance and what had happened. The best way I can describe it is that my field of vision narrowed, and the world around me began to turn gray. I thought I could push through it and understand and figure out what was happening, but I could not do it by myself. At times, I was frozen with indecision, and this is when I really, really messed up. I used client funds to pay bills that I could not cover, including the 401k shortfall. I was not thinking clearly, and the red flags and the alarm bells that I would have expected were not there. I did not see options in front of me. My actions were wrong, and they were short-sighted. I never dreamed I would ever do that. I've repaid all the money, but that does not undo what I did. I realized I needed help, and I'd really messed up. I felt horrible about removing that money and using it, and I was punishing myself with the guilt that I carried. So in early March of 2017, I went to my pastor, and I told him what I had done. I confessed to him, and together we asked for God's forgiveness. I also scheduled an appointment with a counselor and began to try to understand what had happened. Through both of them, I learned about depression and anxiety and grace and mercy. Depression is not something that I'd struggled with throughout my life. I'd always tried to keep a positive outlook and be a problem solver. I now faced a crisis on both my spiritual front with my Christian faith, as my actions did not match my values and my beliefs, and of my identity as a decent person, as an attorney who had practiced for many years with integrity. I went to my attorney and I told him what I had done. He referred me to Mr. Ambrosio, and I self-reported my actions. And speaking of depression and anxiety and what it was like, not to excuse my behavior, but to present a picture of what it was like. I have taken steps to address the depression and the anxiety. I've been in counseling since March of 2016. The first year I went weekly, and I've gone every other week since that time. I've been on medication for depression and anxiety since May of 2016. I have taken it faithfully, and I continue to take it daily. And I will continue to take it as recommended. I'm in pastoral counseling, and I meet with the pastor at least one time a month. He has helped me walk through the dozens of questions that I have had and been a steady presence throughout my journey. We talk by telephone almost weekly, and at my pastor's recommendation, I spend time each morning with a daily devotional, and I keep a journal. I'm also spending time in meditation with a meditation app each morning and night. I signed a monitoring contract and I actively participate in KLAB. I have a volunteer that I meet with monthly and I participate also in a Skype group. I have complied with the monitoring contract and I found the volunteers' insight and support and the Skype group to be helpful. These tools have helped me stay focused and to be resilient. I have reduced my work hours, have systematized all my office processes, worked on my time management skills, my delegation of duties, and the office is running smoothly. I'm now sleeping well, I'm eating right, exercising regularly, and I'm losing weight. Once again, I'm reading, working puzzles, and engaging in social activities. Excuse me. My husband and I have improved our communication and are working together to get through this. I'm still my parents' primary caretaker, but I've learned to delegate more and to set appropriate boundaries. I have tremendous support from my husband, my family, and some very supportive friends, and for all these things I'm very grateful, and I'm much healthier. I'm aware of the seriousness of my actions. Through all of this, I've learned a tremendous amount about myself and also about depression and anxiety. Depression's like a dark hole that messes up with your thinking. You get stuck in negative thoughts and cycles. The thinking's not healthy. I've learned that if you do not take care of yourself, your health can greatly deteriorate, and when your health is compromised, it impacts your ability to evaluate information and to be able to make good decisions. And that's what happened to me. I have learned that I cannot do it all myself. I have learned the importance of setting and keeping boundaries and to address problems or concerns immediately when they occur. I have learned to use the tools of meditation and mindfulness to focus my thoughts on the present moment and to stop or break off the cycle of negative thoughts. Working through the depression and the anxiety and the guilt and the shame of what I did is the most difficult challenge that I've ever been through. But I'm diligent about my self-care and determined to continue to gain skills and to stay healthy. I've regained my health and incorporated healthy habits, and I feel better now than I have in 3 years. Depression and anxiety are a growing problem in our society and in our profession. Some of the qualities that make us good attorneys, attention to detail, long work hours, caring about others, wanting to do the best job possible, and our perfectionist tendencies cause us to be more susceptible to stress, burnout, and depression. We are taught to be self-sufficient. We believe that we can do it ourselves. And we think that we can push through and figure it all out on our own. I know I thought that, and I was wrong. And the belief that I had in the lack of care of myself has cost me dearly. I do believe that KLAB is a good program and is much needed in our profession. When it's appropriate, I'd like to someday be able to offer myself as a volunteer to help others that are going through these challenges and to share what I have learned. The last couple of years have been very difficult, and I've learned a tremendous amount. My actions were not appropriate, and I continue to feel great remorse for that. I worked hard with every resource and every tool that I could locate to understand what happened. And I've learned a great deal about how our minds work and how important self-care is and how far one can fall if you don't take care of yourself. I have insight into what happened and the tools and the determination to make sure that it will never happen again. I take responsibility for my actions. I've been cooperative throughout the process, and I accept the court's authority over me and my license. I love my work, and I care about it and my clients, and I would humbly request an opportunity to be able to come back at some time. Thank you.
Thank you,
I think
counsel.
it's important to note that I did not write, nor did I edit in any way her statement. I think that's important. Thank you.
Thank you both.
Take care. Pleasure.
You get, okay.
Thank you.
Go back to the table. Now.
I certainly appreciate the efforts Ms. Thompson is making and has made, and I hope that she is on a much better path. I do need to make a few comments, though. She focused on the loss of her friend in December of 2016, which I'm sure was very difficult. But by that point, she had already withheld and kept her employees' funds for almost a year at that point. She had already written herself 3 checks totaling $10,000 before November of 2016, which she did not request permission to pay herself, nor did she receive permission to pay herself. She talked about going to her pastor in March of 2017. I would note that that is at least 2 weeks, if not more, a month or more after the complaint was filed in this case against her. As far as the therapist's testimony in this FOG, that was covered in the panel hearing, page 17 and 18 in the report, and the panel explicitly rejected the therapist's testimony in this FOG. It was essentially she was in a fog every time she did something wrong. The panel rejected that. She also provided evidence at the hearing of good reputation and that she had people testify on her behalf in a bunch of letters. I don't dispute any of that, but I think that cuts both ways. She did enjoy trust of her colleagues and of the court in Wichita, and that allowed her to take advantage of that position and take this money. The panel majority.
I have
Sorry?
a question.
Yes.
I've looked at all those letters, and I was struck by how genuine many of them sounded, and not like form letters that somebody, jotted down 2 sentences and sent them off at the request of a respondent, which we sometimes see. Do you have any thoughts on whether they were an unusually high number of them, or about their content?
Unfortunately, this is a new territory for me, as I think as the court knows. I don't know what an average number. I certainly understand there were a lot of letters that were written.
And a lot of them from her fellow lawyers.
Yes, and people that have known her for a very long time. I don't dispute anything that those people said. I think that there's a very good chance for a very long time Ms. Thompson was very respected and did a very good job. But as I said at the end of my earlier argument, there are just some things that we know as lawyers you just don't do. And taking money that doesn't belong to you, especially almost $90,000, is one of those things. The panel majority did, 2 of the 3 panel members did recommend indefinite suspension. I would note, though, that they recognized the severity of this conduct, they recognized the applicability of the ABA standards, and they still recommended the indefinite suspension, which surprised me to some extent. But I would note that Presiding Officer Williamson was very clear that she believed this was a disbarment case as well. I would just note to close that if the court does impose a suspension, I would certainly recommend a reinstatement hearing under 219 before she'd be allowed to practice, but I am asking for disbarment.
Thank you, counsel. We thank all of you for your arguments this morning and this afternoon. The court will take this matter under advisement.